My name is Judy Foreman. I'm an attorney practicing in Los Angeles, 35 years. Well, welcome everybody. Our panel this morning is going to try to define some concepts for you. We're thinking about decision-making and opinion-making in family court. What makes for a well-informed and well-considered decision or an opinion by an evaluator? And what are the impediments to that kind of a decision? How does this really play out in the real world? And are our goals only aspirational, or is there some reality base to them? To my left, the Honorable Mark Uhas. Judge Uhas has been sitting as a family law judge in Los Angeles Superior Court for the last 11 years. Judge Uhas has been a member of the Elkins Family Task Force. He participates in numerous committees in the court system with the Judicial Council, sits on the Family and Juvenile Advisory Committee to the Judicial Council, and chairs the Family Law Curriculum Development Committee for the California Center for Judicial Education and Research. To Judge Uhas's right is Dr. Margaret Lee. Margaret has worn so many hats, I don't know how to list them all. Evaluator, expert, consultant, mediator, special master, co-parenting counselor. Margaret has written extensively and spoken extensively on family law matters relating to child custody, to attachment issues, alienation issues, the role of the forensic mental health professional in custody cases. Everything I just said about Margaret, I might echo about Dr. Robert Kaufman, Bob, who's sitting to my immediate left. Bob also has worn all the various hats that Margaret has.
So as I'm sure most of you have noticed, we're starting to pay more and more attention to the cognitive and sociological research on bias and actually on error. That it's seeping into our work. You know, we're in this world where we are collecting data, we're thinking about data, we're rendering opinions, and some of us making decisions. And their decisions, they sort through evidence and they sort through the opinions of others and the evidence collected by others. And they're in a position of making decisions that are very serious and will have long-range implications. As a custody evaluator, we're in the position of gathering a lot of data, can be biased, that can contain error, which then becomes the basis of our recommendations. What we're hoping to do with this is to talk about what's the best way we can make the best, most informed opinions and decisions, with an acknowledgement that we are human and it will be imperfect. On the issue of bias, and when we talk about bias, we're also going to include other kind of cognitive errors, errors of attention, that create which then can put us in a position of coming out with a biased or an inaccurate kind of recommendation. So a big question is, can it be eliminated? Another question is, what form does it take in the family court or in the family court arena? So where do we see bias popping up? Where do we make errors? How can we pay attention to those? Also, we were interested in the question about whether there's a relationship between bias and fairness, and whether there's a relationship between bias and credibility.
Good morning, everybody. Nice to have you here and to be here. Just to add one other thought to what Margaret was talking about that's occurred to me, also is a question of not only should we be managing our potential for bias, but should we be doing something about the perception or the possible perception of bias? In other words, we may feel that we have been very neutral and forthcoming and done a good job weighing evidence, but is there some responsibility, and I think that could be for any of us up here, to demonstrate to the consumers of our reports and the people that we try to help, should we be trying to demonstrate our impartiality, and how important is that also in the process?
Can I add 2 cents? The credibility of the judicial system is based on it being not biased. And so to the extent that any of the litigants feel that any part of the process is biased, for the other side or biased against them, or maybe even biased in their favor, then we've got a big problem. So I think it's critically important that we keep in mind that in answering the question that the doctor proposed, I think clearly it's important that we make sure that as best we can, we address the bias issues and make sure that we're keeping that out in the open. So this morning I called my calendar, and there was a gentleman who I had to dismiss his case because the law obligated me to dismiss his case. And maybe because we've been having these discussions, it ran through my mind, it's really important that this litigant understand and believe me when I say the law obligates me to do that, as opposed to I'm just doing it because I don't want to deal with your case, I can't deal with your case, I've got something else to do. I mean, whatever the reasons he may be thinking, he took 3 days off of work. He was told by our self-help center that this was the process to take. It wasn't. And so he's now in a place where the ultimate credibility of the legal system rests with me and him believing that I'm telling him the truth and that I'm not biased against him in some way. I think it's important to keep in mind that in most jurisdictions, Texas allows jury trials for custody cases. I think that strikes me as being an interesting way to do it. I suspect folks from Texas think that it's a good way to do it, but most jurisdictions don't allow jury trials for a custody case. So judicial officers are no different than any other human being. We have biases, we have things we like, we have things we don't like, we have ways of approaching things and all of that. I think that the threats to neutrality in a judicial officer tend to be things like personal experience of that judicial officer, the experience with the case, how that case is unfolded before that particular judicial officer, experience with the attorney that's appearing before that judicial officer. And then there's other things. There's a judge out of Minnesota that some of you may know by the name of Kevin Burke. And Judge Burke has done a tremendous amount of really good work lately in access to justice issues and in decision making. In fact, he just wrote a white paper. If any of you are interested in it, let me know and I'll get a copy of it to you. But he just, I think it's on our, did we provided it, didn't we? I think it's provided, right, so you've got it. But basically it talks about the same things that mental health professionals face as bias, confirmatory bias and all of that, judges face as well. And we're going to flesh that out a little bit as we get going. But there's also a lot of things about decision making that you need to keep in mind. And decision making, how that process works and what a judge does when he or she's making decisions is important. For example, like I said, we'll flesh it out a little bit as we go. But the number of decisions that a judicial officer makes depletes that judicial officer's store of calories to make more decisions. And so it's interesting when you think in the terms of are judicial officers making the same decisions before lunch that they're making after lunch. And there's a great study out of Israel that shows that they're different. Also, from my own perspective, I can tell you that if I walk into a trial and there's 500 motions in limine that I have to decide before I actually start then making a decision, my decision-making store may be depleted before I have to make a major decision because some lawyers ask me to make 1,000 little decisions that may or may not have importance in the case. And so if my decision-making store is depleted, then I'm going to start wondering personally whether I should be making larger decisions because I'm in a place where, I'm tired. I've used my calories. And so, and I mean calories in a literal sense. Decision-making takes brain power, which takes calories. So I think those are things that we all need to keep in mind. Good decision makers know when they're in a place they shouldn't be making decisions. There's a great article not long ago in Vanity Fair about President Obama. President Obama does not decide what color suit he's going to wear because that depletes his ability to make another decision. So at that level, as that decision maker, he's decided that, that's just a decision I'm not going to make.
Do I have to worry about whether you read my trial brief first? Do I have to worry about the primacy effect? Do I have to worry about whether or not my opponent has served on panels with you for family law symposia? Do I have to be concerned about what time of the day my trial starts?
So let me answer those questions in no particular order of importance. Do you need to worry about any activity that the bench officer, and I'm going to expand a little bit, any activity that the bench officer has in the bar? The answer to that would be you really shouldn't, because at the end of the day, that shouldn't bias the judge one way or the other towards or against an attorney. I mean, I think it's, I take the perspective that I disclose everything. So the next time that Ms. Foreman appears in my courtroom, I will no doubt say, we made a presentation at AFCC, it involved decision making, I'm disclosing that, you need to know that. If you want to ask me any questions about it, feel free to do so. I have no feeling towards or against Ms. Foreman. But that way it's out there. I think that in the world of increasing numbers of self-represented litigants, they don't have the same level of confidence in the judicial system from the get-go that lawyers do. And they don't have the same level of confidence that they're always a little concerned that there's a deal going between the lawyer and the judge. And so if you disclose all of that, then that solves that problem.
Could I just jump in for 1 second?
Sure.
I don't think it's just the self-represented litigants.
No, it's not.
I think given the potentially really sophisticated consumers of legal services who have computers, laptops, iPads, iPhones at their fingertips, they're going to be sitting and looking up things themselves, such as how many panels did Judge Yuha sit on with Mr. X? And Mr. X is on the other side of the case, and am I going to get a fair shake in that courtroom for that reason, no matter what Judge Yuha says about it?
Right, that is true. And I get Googled all the time. There was an appellate brief that I just read that it's apparent that the writer Googled me because he talked about other cases that are unreported that I was discussed by an appellate panel. So, I mean, all that's out there. There's no question or doubt about that. There's actually some interesting, we're now a little bit beyond the topic of this presentation, but there's some interesting work that's being done in California, and I know in other states as well, about judicial officers Googling themselves, whether they can or whether they can't, whether you should, whether you should talk about that when you do, that sort of thing. There was a recent case out of Texas where a judicial officer was challenged because of some things that happened on Facebook. And so, I mean, all of those things are swirling around out there, and that goes necessarily to bias. I think a lot of bias, at least in a judicial officer, I can't speak for an evaluator, but a lot of bias in a judicial officer gets addressed by that judicial officer disclosing everything that he or she thinks is important, and then disclosing things that he or she doesn't think is important. I go so far as to say, if I remember that I had a case with a litigant 30 years ago, I disclosed that I had a case with that particular lawyer. I don't really remember much about it, but I remember I had a case. I disclose it, and then, then everybody can make whatever record they want to make. I personally think that's important.
But then don't you have to do a second kind of level? You can disclose it. You can even be aware that, oh, yeah, I knew these people. They were on panels with me. Mm-hmm. How do you really know that that isn't influencing you and your thinking?
I think, well, you don't really know. At one of our breakfast, at one of our comments, at one of our discussions rather, I made the comment that, it's the bias that you don't know you have is the dangerous bias. The bias that you do know you have is easy to think about and address. But you go back to, again, the decision-making process. If I'm falling back on an easy, quick decision-making process, I'm necessarily falling back into, as are the evaluators, I'm just using me, but as are human beings generally, falling back on to quick and easy decision-making. When you all drove here, you all flew here, you made quick and easy decisions based on schemas that have worked out well for you in the past. And so, there comes a point that even in a decision-making, in any evaluation, you do that same sort of thing as well. And when you fall back on those schemas, if you don't know what they are, you don't know where your decisions are coming from. I think the only thing is to be very cautious and do self-tests and make sure that you are thinking through your decisions and that you're not making decisions quickly.
Confirmation or confirmatory bias is perhaps the most common in family law, but it's probably a concept that's overused and perhaps sometimes inaccurately used. Confirmatory bias, seeking evidence to bolster previously held beliefs, and then evidence is evaluated in light of the belief rather than the fact pattern presented to the evaluators. Anchoring, as I understand it, considering a particular value for an unknown quantity before estimating that quantity. So you take some information that may or may not be relevant, and then you're primed with that piece of information, and then you evaluate evidence in light of that first initial impression or idea, confirming, disconfirming, how much does it move off of this particular anchor.
Can I just give a quick example of that? So, for example, if you're an attorney and you tell your client, you know, if you fight this and we take it to court, it's going to cost you $100,000. And then when it ends up costing $40, it seems like a great deal. Maybe, you know, so it's that kind of situation where you're given a preconception or a notion, and that then other information is weighed against that. There's some studies in it that are just kind of really fascinating in the legal arena.
One thought I had, you might have, for example, somebody who comes in, a client who comes in and says, well, my ex-husband has been diagnosed as narcissistic personality disorder and antisocial personality disorder by 3 psychiatrists. And they tell you that at the beginning, and this, of course, is thoroughly enthralling for an evaluator. Great, I can hang my hat on that. And then you start looking at the evidence, not in the whole and not necessarily on the effect of parenting, but trying to decide, is this really a narcissistic personality disorder, and how does the narcissism, because you've already been primed for these characteristics.
And you've totally missed the fact that that person who told you the information has a delusional disorder.
I thought in child custody, I thought it automatically meant the other person was borderline. So there you have it, 2 different theories.
God, your system 1 is going again.
Yeah. Well, and I think I'm going to at least note also what has come into the literature to some extent of a countertransference bias. And countertransference, which many of you may know, stems from historically older Freudian or analytic idea that comes out of the therapy context. And but the concept here is where some issue in the evaluation could activate something salient in the evaluator's past history or their really strong beliefs, probably based on past history, and they may then start to over-identify with the patient and lose with the patient. There you go. I'm back in the therapy world now. But you could over-identify with a view of a particular parent in the evaluation. So you might find, for example, a parent who demonstrates certain kinds of parenting approaches or techniques that the evaluator thinks are either, let's say, way too rigid or even way too permissive, and then or somebody, a parent in their own history who has had certain experiences that then start to mirror something in the evaluator's past, and then it activates, as I say, either an over-identification or maybe even an antipathy towards that person that then, again, it interferes with their ability to stay neutral and gather information in a 3-dimensional and accurate way.
That would be applicable to the judge as well. all of these concepts that you're talking about?
Yeah, I think we'll be
Applicable to all people.
Not the lawyers, no.
Every way. Well, your job isn't to be neutral and objective.
Absolutely.
So you don't have to hold yourself, so you can like go crazy with your biases and errors.
I'm not worried about my biases unless I think that it's interfering with my assessment of the case, of the pros and cons, weighing issues such as, should there be an evaluation? What do I do with the evaluation? Should I go to trial? Should I not go to trial? Those kinds of decisions, I acknowledge, can be definitely affected by bias. Most of the time, I'm concerned on the other side. And I think that from an ethical perspective, what the lawyers need to keep in mind is that we do have an obligation to advocate zealously on behalf of our clients, but I think the word zealous has been overused. I think a better word might be responsibly and ethically, rather than just the word zealous. It has other implications. If you take a look at the Code of Professional Responsibility in California and Code of Civil Procedure 128.7, for anybody who wants to be a policy wonk out there, think about what statutorily the lawyers are supposed to do in terms of presenting information to a court. I don't know how many people really read that statute before they file their briefs, though.
Okay, I think I'm going to take this a little further. I'd like to just give a countertransference bias because I identified it in myself after 10 years of therapy. I have this really wonderful, I had mild-mannered father who was really successful but never talked about it. He was a scientist. He never showed his love, but you always knew he was completely there for me, for my siblings. And, you know, I started realizing when someone walks in my door, this kind of low-key and modest and a sweetheart and a mensch, I mean, it stirs up all those feelings, all those attachment things for me. And I have to pay very close attention to it. I might have a much more negative reaction to someone who comes in and is kind of, this is who I am in the world and I'm really terrific in the world and you know, articulate and socially kind of skillful. So it's kind of, that's one I know, and I kind of keep that in my back pocket, that knowledge that I have to watch out for it. Kahneman obviously is one of the fathers of our thinking about bias and error and how we work as human beings, and his work is fabulous, and I think so important for the work we do. So his idea, this idea of fast thinking versus slow thinking, that we have basically two systems. It can also be looked at as intuitive thinking versus analytic thinking, system 1 and system 2. System 1, as Mark was saying, we all got here to LA. We probably didn't think about a lot of the things we had to do on the way here. I actually didn't think much about packing because I was thinking about our presentation, and somehow I ended up here with an outfit that works well. You know, so it's like that was done pretty just kind of on the back burner. That system 1 is instant, effortless, unconscious, and it's running all the time. We're just picking up information, making decisions, having behaviors that we just don't think about. And it's very intuitive, and it comes up in our work where someone walks in the door and maybe you get a take on them. You know, you kind of get a sense. System 2 is much more deliberate, and it takes what system 1 has thrown up, was that a saber-toothed tiger, and thinks about it, and is deliberate and analytic. One thing about system 2 is it takes a lot of attention, and it is very tiring. So when we are working on our custody reports and we're trying to put all of this data together and the room looks like a mess because you have piles from the different data sets and you're trying to make sense of it and pull it together, you are engaged in a lot of system 2 processing. So just a couple of quick examples. So you have I always see people together for the first meeting of a custody evaluation because I don't want anyone to tell their story first. I want them both in there. I want them to tell their story together. I want to see how close it is. Do they describe the same kids? What's the history? So, you know, a histrionic mom and a narcissistic dad walk in my office. It's very easy to go, I know this story, I know how it's going to end, and I know what I'm going to probably recommend in 3 months. You know, it's so easy because, you know, I've seen this. That's my autopilot. And you got to stop and say, well, okay, let's just collect a lot of data and see what happens. Another is that kind of fast thinking where a 2-year-old, father of a 2-year-old comes into your office and you go, got to start overnights. Want to have, you know, good attachment relationships with both parents because the research says that father involvement is so important. And it's that kind of auto-thinking without going, well, what about, is it with this father, this 2-year-old with this history? Does it make sense?
How long will the parties live with that when they get to their 5-day trial?
I'm going to recast that slightly. There's a different concern as well. People that are in the beginning stages of a dissolution or the beginning stages of a custody fight are different than people that are 6 months, a year, 2 years out. And so if you have an impression that's developed around these people at this time, how do you get the bench officer to see that these people are growing and changing and becoming more reasonable and, you know, whatever's happening over time? Are you stuck with that? That would be a much bigger concern in my mind than the quick and dirty ex parte.
But if, for many of us who may take 3 months, maybe 4 months, depending on what's going on, but somewhere in that range, I think it's fundamentally different cognitive processes. I mean, I actually, I like doing them somewhat more slowly over a few months because, number one, people can't hold it together that long, so you kind of see some of their underlying characteristics.
So should my strategic goal in trying to manage the evaluation process be to make it string out as long as possible?
Depends who your client is.
Yeah, I've seen that goal many times, but it's actually, it raises some other questions actually about when you cut off data collection. And
that also assumes that the court is not going to control the pace of the litigation. I think increasingly family courts are increasing how the litigation proceeds. Historically, the thought had been that when folks are ready to finalize their case, they'll come back to court and they'll say, we're ready to go, and then we'll get it finalized. I think more and more courts are taking control of the case and moving the case through the system and getting it finished. Part of that is based on some research that's been done that people that file for divorce, for example, actually want a divorce. They really do want to get through the system.
I thought they just wanted to kill each other. Metaphorically.
So, you know, and in an era of decreasing judicial resources, keeping cases moving along becomes very, very important for the court. And so, you know, it would be nice if to leave the litigants in control. Increasingly, I think the courts are going to be taking control of the pace of that litigation. Now, if there's reasons to keep an evaluation over time and all of that, that's one thing. Also, you know, I mean, parties complain, both represented and unrepresented, complain about the increasing cost of dissolution. And so keeping an evaluation going forever just causes the cost of the dissolution to go up. And I think people are thinking more and more along the lines of, and I got to be honest with you, you know, it's not uncalled for a judicial officer to look at people and say, you know, do you want to spend this money or do you want your kids to go to college? And so that becomes a concern of litigants as well.
But do you think that it would be appropriate for the judicial officer to take an activist role in directing the pace of the evaluation?
Well, I'm not sure. I don't know that I understand the question you just asked. Do I think I should call up Dr. Lee, Dr. Kaufman, and say, okay, you know what, you guys are going to do this, you're going to do that, you're going to do by this? No.
Or get it done.
Or get it done. Do I think I should be able to call them up and say, you know, what are we doing here? Yeah, absolutely.
So what's your clock on that? 2 months? 4 months?
I don't know.
Does it have to be initiated by the lawyers?
Maybe. Maybe, or by the third status conference, well, they're saying that Dr. X is doing X, Y, Z. I think at that point in time, it may be okay. We gotta get this done, or somebody needs to tell me why it's not getting done. And this, I mean, we're in an area where I think collaboration between the evaluator, the attorneys, and the bench becomes critically important. I don't know whether I don't remember who I was talking to. But an evaluator was talking about that they were halfway through an evaluation and there was a tragic death in the family and one of the children was killed. And that's clearly, we got to put everything on hold until everybody can digest that and move through. I don't know about your particular situation, but I do think that's where you go into the bench officer and say, yeah, I know it's taking a long time, but this is why, and the bench officer needs to be sensitive to that for the needs of the family. If it's just, I'm busy or I've got a vacation or something like that, that then becomes a different. And if one side or the other is not cooperating in the process, then that also is a different reason to pick a different schedule.
For mental health people, our ethics mandate that we pay attention, be culturally sensitive. I see though two major areas that cultural issues really come up. What I see happening as in evaluations is attributing motive to a behavior, and that the behavior is a cultural expression that has a different meaning, and not really looking at that.
It's also important to keep in mind that we speak a different language than most of the folks speak. These folks are very, very good in their world. They can, fix a car, they can fly an airplane, they can perform surgery, they can write an evaluation, but they're now in our world, which is much, much different. And so someone that's very articulate and very smart in English may not be able to keep up with some of the language in a courtroom or some of the language in an evaluator's office. And I think that really needs to be kept in mind. That was, I'll digress for just a moment. I had an opportunity to take a trip, and I had to get some malaria pills. And so the public health nurse spent 20 minutes explaining to me how to take these pills. And there's only 3 of them. But it was like every other day, and they had the refrigerator. It was just it was really sort of a mess. But she spent a long time trying to explain to me how to do this. And I thought, I'm a pretty bright guy, and I cannot for the life of me understand this. So finally, you know what she did? She wrote it down and handed it to me. You know what we call that in our world? A court order. So just keep in mind that people may be very, very good at what they do, but are going to be like a fish out of water in our world, and then that doesn't make them not credible, doesn't make them not telling the truth, doesn't make them all sorts of different things. It just makes them uncomfortable, which is very human.
Mark, I think this is you.
Okay, so let me sort of talk about a couple of other things that I think we've touched on a little bit. And keep in mind that a lot of what we're talking about is human nature. This is how we're wired. It's how we get through our life on a day-to-day basis. The studies demonstrate that, oddly enough, if something is easier in a font that's easier to read, you find it more believable. Don't know why, but if you have to struggle reading it, you find it to be more believable. If it happened more recently in time, it's more credible than something that happened 5 years ago, 2 years ago, 6 months ago. So when that person comes to you and says that domestic violence happened 2 weeks ago, that's more credible than they tell you what happened 6 months ago. It may not be true, it may not be more credible, but our mind thinks, well, it's more recent, therefore it's more credible. Also, in our experience, more recent experiences in a courtroom are more credible than something that happened 5 minutes ago in my courtroom is more credible than something happened 3 days ago in my courtroom. So close in time gives something more credibility, whether it should or whether it shouldn't. And then finally, we talked a little bit about the physiological state of the organism. And that's, again, is your decision maker tired? Is your decision maker hungry? Has your decision maker made a lot of decisions already in that morning or that afternoon and just isn't in a place to make those decisions? You know, do you look at how does the decision maker review the pleadings? One thing that Judy asked was, you know, is it better if my brief is read first? You know, in order to stop that sort of thought process, I read the petitioner's brief first. Or I read whoever has the burden of proof's brief first. And that way, I just have a pattern of doing that. And then I'm not just randomly picking somebody's facts and then you know, building a case around them. Whoever has the burden of proof is going to go first. I'm going to read their brief first. Then the next thing I do is read the next person's brief. So I think that you know, there's all sorts of other little sort of fun facts to know and tell, or factoids, or whatever you want to call them. You know, difficult names people with difficult names are less credible than people that have easier names.
Lee. Great. I'm going to be so credible in court.
Exactly.
Great.
Exactly. And so, you know, I mean, some of this is, like I said, some of it's just kind of fun facts to know and tell, and it makes for great cocktail party chatter. But at the end of the day, some of this stuff becomes very, very important. And you need, as you're presenting your case, as you're working through your evaluation, you need to keep that sort of stuff in mind. Another thing is that family law has a lot of pressure, which we've talked a little bit about, on all of this. There is not a family law judge sitting on the bench today that I've talked to, and I think I can say this is true of all of them, that isn't aware of the gravity and the importance of their decision. I'm going to go back this afternoon for a trial. The kid that we're talking about is 2 years old. I understand that the decision that I'm going to make for this 2-year-old is going to affect that child long after I'm dead. And the decision that I make is no doubt going to affect that kid's children. And bench officers understand the gravity of that decision. They also understand the pressure, and we can all sit around and talk about under-resourcing family courts. We can talk about that until the cows come home. But they also understand the pressure that they feel of large calendars, keeping calendars moving. You know, family law courts are a zero-sum game. Every minute I spend with the Jones family, I don't have to spend with the Garcia family. It's just how it goes. So the pressures of making those decisions, the pressures of getting through the calendar, the pressures of getting through that day also weigh heavily on bench officers in making those decisions, much the same way that Dr. Lee talked about when the judge said, get that evaluation done. That then puts pressure on her to start making those decisions. And so you need to be cognizant of your bench officers and your evaluators and everybody. We're all in the system. I just happen to be picking on bench officers because I can. But we all need to be cognizant of the bench officer that's making those decisions, and and maybe be a little aware that maybe this isn't the right time to push that decision. Maybe the thing to do is to push that decision a little bit later, because that makes more sense.
Speaking of recency effects, I think one of the things we talked about also was the effect of going to conferences, which is that there are certain things, I mean, you can take AFCC, certain things become hotter issues and more contested issues, and there can be, it's wonderful because we can all leave here after these days and feel that we've as Leslie Drodes and Nancy Olesen will say, fill up the research tank, right? We can fill up the tank, but how do we fill up the tank? And it's probably more salient to us that our last refill, whether it was last year, meetings about it, where we were focusing on attachment or alienation, and they can influence us, and sometimes even before we've really even metabolized all of the thinking and diverse opinions that we've heard.
One other kind of situation that can make you very vulnerable to bias is retention bias. I think, David, that was you came up with that. And I'd just be real quick on this because we kind of want to focus on those who are who are supposed to be neutral and objective. But if you're a reviewer, you are supposed to be neutral and objective too. So if you are hired to review somebody else's work, I think that you have to really be careful. You're being paid. And, you know, what happens if you start doing a review, you've put $20,000 worth of time into it, and you find a piece of evidence that is a fatal flaw, and you are no longer useful? Those kind of situations can happen. Or you review some material, you say, well, you know, I think whatever, and the attorney says, yes, please review the whole file. And then at the point of reviewing the whole file, which is however many hours in, depending on the file, you say, you know, your client is really problematic in these kinds of ways. You have to be willing to do that. But because you're retained, I think you have to put extra attention to not go, oh, well, that piece of information wasn't really so important. The other thing has not to do with money, but just if you're hired by an attorney you like to work with them, you want to work with them in the future, you always have had good experiences with them, and you really, after reviewing material, you really feel that you cannot be helpful, or you give your opinion and they realize that's not a helpful opinion. But the only way you'll be neutral or be seen as neutral is be willing to do that. I just got a referral from an attorney who I like to work with very much, and the judge would not order an evaluation, but said to this attorney, you can hire a consultant and they can look into it, and I'm going to order that the other parent cooperate with that consultant of yours. And the attorney phoned me up and I said, I don't think I can do that. You know, it's just too bizarre for me.
We could kind of develop this idea that this kind of slower paced analytic system to yada yada thinking is really the gold standard, and that we should always be striving to be so thoughtful. And then, of course, that's not like really what life is about. There are really good reasons to engage sound System 1 decision making. I think we mental health people wear different hats. Either from these lengthy evaluations to mediation, recommending mediation, or parent coordination, and we get tasked with making different kinds of decisions along the way. So, for example, in parent coordination cases, you might be needing to make a decision right on the spot on whatever it might be, change of custodial time for a particular week, or some trade, or some after-school activity, or something like that that really is time sensitive and you need to jump in. I think where I came with this is, can we match the thinking system with the decision-making demand? In other words, can we be as thoughtful as we can in situations that require ample thought, and not apply the kind of automatic, schematic thinking to things that really warrant more attention? And can we apply sound automatic or more reflexive decision-making to things that really are time-sensitive and can't be left for 2 weeks to mull over when there's there's a decision about an activity at school or something, and there's a deadline to be made. So I think that we're tasked with different kinds of decisions or recommendations that we have to make along the way. I know that I don't do parent coordination anymore, just for all the obvious reasons, but a lot of wear and tear and babysitting, a lot of bickering. But however, when I did, or even on mediation cases, I really like to inform people, watch out. If you think I'm going to come in and solve your problems, after 1 or 2 sessions with each of you, forget it. nothing's gonna happen for a month or something like that until I get a feel for the case and get enough information to balance pro and con. And I think I only wanted to mention one other thing in custody evaluations. Along with this kind of notion that we always have to be willing to shift our thinking, and that bias and all these things can interrupt that potential shift process. Things can happen in an evaluation at the last minute. New information can come up. Some kind of development can come up. At a point where we're really tired of the people, we just really want to get it off of our caseload. We've got other people demanding our time for all of the really...
Our loved ones hate us at this point.
The less delectable reasons, but we need to have a judgment call on whether we really do need to slow down the process again to take into consideration information that may be new.
Right. I think that, from a judicial perspective, there are calls that need to be made immediately. The kid came back from dad's house and had been abused or something. Whatever. Those kind of calls need to be made immediately. For the most part, though, to the extent that the bench officer can be given some room to have some time to think about it, that would be very helpful, I think, for bench officers. I think that would also be very helpful for the outcome. That may not be possible. We talked about large calendars and all that sort of stuff. It may simply not be possible. I think that one thing, though, that is important to keep in mind, that overwhelming the evaluator, overwhelming the bench officer with unnecessarily detailed information is not going to lead to a better outcome for the most part. I can't speak for the evaluator, although I do know from some of the complaints that I hear that, when you have 4 Beacons boxes full of material to read, you put the evaluator in the place of reading all of those things and making a decision of what is or what isn't relevant and all of that sort of stuff. Bench officer is the same thing. If the bench officer ends up with 5,000 pages of material or 3,000 exhibits, at what point is the bench officer going to read those and then make that decision, this is relevant, this isn't, this is relevant, that isn't. And so if you put the decision maker in a place where they're expending all of their energy and, again, making all of those little decisions, they're not going to have any for the big decision.
One of the things I would say, certainly in terms of evaluations, custody evaluations, we do have some safeguards in place, and they have to do with procedural safeguards. In other words, we're mandated to do certain things. One can no longer get away with having a couple of quick sessions with the parents and seeing the kid and write the report. So I just want to point out that I think that those bodies like AFCC who have come up with custody guidelines and local rules of court, I think have had their eye on the potential for making decisions and recommendations with inadequate data. So just outlining a few areas where we might be wanting to check along the way of what we're doing in an evaluation process. Here's a list of questions I thought of just off the top of my head we could ask. We could be asking ourselves as evaluators, in terms of kind of keeping the ship righted. Is there something going on with the referral process from the attorneys? We usually have conference calls with the attorneys ahead of time when they have inquiries about the evaluation, and you start to hear the arguments straight away. How are they framed? We have some pull to want to work with or please a particular attorney, etc. Do we already envision it as a kind of thing, following up on what Margaret said, as kind of an easy case versus hard, etc. The lure of these high asset cases. And then I did add, so sometimes I've had instances where the referral has virtually come from the bench, and so that can feel like something that cannot be refused. And what does that mean? Or if we suspect that there might be a consulting expert behind the scenes. already? How does that affect us? So I just thought I would just kind of skip to the last part when putting together recommendations, and I actually think these are pretty good questions to ask ourselves. Have we been, thorough, or what's fueling? Have we considered the hypotheses? Have we let our feelings about one or the other parent interfere with the recommendations as we put them together? Are we writing reports defensively because we know somebody's going to be out there, or the case has been kind of posed as a highly litigious case and therefore are shying away from expressing a stronger opinion? So I just put this out there as the process can be complex, and I think over time you get the ideas, you get to know where your potential weaknesses are, and so you hopefully narrow the list down to what's manageable and reasonable.
Well, I think it's really important for us, certainly from the lawyer's perspective, to differentiate between the anxiety of the client and the lack of familiarity with the process itself versus something that actually might be content related to the evaluation process. And if there's anything that happens that might graduate from a level of, let's say, concern, mild concern to great concern to really being worried and alarmed that something bad is happening. That's only happened to me once in all these years, where I actually did file a motion to terminate the evaluation. I gave you, one of the handouts in the back is a portion of that motion with everybody's names expunged. And interestingly enough, no matter how alarmed I was, the court denied the motion and said that it really went to the weight of the evaluation. I thought it was a bad decision, but that's the way it goes.
I think basically the message here is we're in a very difficult situation. We are confronted with threats to our neutrality and objectivity all the time. We will be biased at times. We will make errors. That have other people review your work and give them permission, explicit permission to nail you, to catch you. Also present your work to other people. So I'm in 2 study groups. I have a Rorschach study group, go over all the scoring. I have a forensic study group. Bob is in that. We go over our cases. I then have someone read my final report before it goes out. Most mental health people from my generation, part of getting a PhD, you had to go through psychotherapy, individual psychotherapy. It gave you the opportunity to get to know the skeletons in your closet. If you have not done that, it's a really good idea. Otherwise, I would just be giving children to those mild-mannered, nice men who came into my office. And if you have a case where there are cultural differences, find somebody to give you some information about that culture. I've talked to professors who are expert in the Basque culture. I found mental health people who are Chinese and have studied that culture. I've spent a lot of vacations in Spanish-speaking countries. And so you need to get consultation when you run outside of your knowledge base in cultural issues.